It's about history, policy, and impact. A new perspective on current affairs, bringing experience, insight, civility, and scholarship to the urgent issues of today. It's about our past, present, and future. Your host, Pulitzer Prize-winning author and journalist, Douglas Blackmon. From the University of Virginia's Miller Center, this is American Forum.
Welcome back to American Forum. Americans are living through a time of profound doubt about our systems of justice. Police officers are under indictment for allegedly murdering civilians on our roughest streets. More than 300 people who had been sentenced to death or lengthy prison terms for terrible acts of violence have been proven innocent as a result of new DNA technology. It's now all but certain that in the past, we executed many innocent citizens for crimes they did not commit, and that even today, yet more innocent prisoners probably remain on death row awaiting the executioner. And at the highest levels of society, Americans remain broadly frustrated that there has been little punishment of the executives at banks and other corporate players whose illegal manipulation of financial markets triggered the economic collapse that cost Americans billions of dollars, millions of jobs, and for thousands, their homes and savings. Joining us to sort through this confusing legal landscape is Brandon Garrett. He's a distinguished professor of law at the University of Virginia, the author of a seminal book on false criminal convictions. He is also the author, most recently, of Too Big to Jail: How Prosecutors Compromise with Corporations. Thanks for being here.
Thank you.
So the two books that you have written, both of which I've got here in front of us, in some sense capture the range of this confusing American relationship with our justice system right now. And on the one hand, it's a book about over-prosecution of poor people and minorities in some respects at one end of the spectrum, and at the other end of the spectrum, you've written a book about whether it's under-prosecution or confused prosecution of a very different set of players in American society. But so how did we end up, in broad terms, in such a state of contradiction about our justice system?
Well, I think we should judge our criminal justice system by how well it handles not just the cases of the least privileged offenders and the innocent, who obviously shouldn't be charged or prosecuted at all, but we should also judge our system by how it treats the most privileged offenders. You have cases where companies spend literally hundreds of millions of dollars on their own defense, more than the money spent in entire criminal justice systems on the defense of the poor. And what's fascinating about these corporate cases is that the tables are turned, and all of a sudden the prosecutors look like the David to a corporate Goliath. And so I do think it's important to look at the high and low to see what's wrong and what's out of balance in our criminal justice system.
But why don't you start with back before the financial collapse, in the period of the big accounting scandals that so many corporations ran into trouble on, and in particular, maybe most famously, Enron and Arthur Andersen, but the approach that the government took to those cases and then how that played out.
Yeah, so corporate prosecutions have gone through an unbelievable metamorphosis over the last 2 decades. It used to be that no one talked about how to prosecute a company. The idea was, well, what's the point, really? You couldn't really find them very much before the sentencing guidelines took effect for corporations in the early 90s. And it was really, really unusual to even bother prosecuting a company. It just wasn't a priority. That changed in the 90s, and you started to see here and there some corporate prosecutions. A company can be prosecuted for the act of any of its employees if they commit a crime.
Effectively, like the company is another person.
It's like a master-servant relationship in a way, and it comes from master-servant law. The corporation is the master; it is responsible for what its agents do. So prosecutors have had this power to go after corporations for more than 100 years. And there are incredibly broad criminal statutes which they could use in federal courts to target companies, but they didn't start to do it until really after Enron. And I think the concern was, well, look, if you convict a company, you could put it out of business. There are so many suspension and debarment charter rules where a felony convict can't do business with public companies. You can't do accounting for public companies if you have a felony conviction. Now, a lot of those rules were designed for people like you and me, right? A doctor or a lawyer or an accountant might get debarred if they're a criminal. Well, the rules apply to corporations too, and the concern was you would literally have a corporate death penalty if you convicted companies. And that's what they said. Prosecutors then used the corporate death penalty. They used it against Arthur Andersen. And that's the story with which I open the book, where you have document destruction on a scale that few had seen before. Arthur Andersen gets wind from the SEC that they are going to be investigated for their role in doing the accounting for Enron.
And back up just a second and remind us about Enron and what had happened at Enron and sort of how Arthur Andersen came into that story.
Well, Arthur Andersen was doing a huge amount of work for Enron. It was one of their top clients. The partner, David Duncan, who was in charge of the Enron account, was a rising star within Arthur Andersen. Arthur Andersen was trying to shed its image as sort of stuck in the mud accountants. We're doing exciting things now. We're actually embedded within companies and sort of consulting with them. Basically, when the SEC indicated that they might begin investigating Arthur Andersen, everyone freaked out. There was panic. And what they did was they had multiple meetings at which everyone was told, by the way, you should heed carefully the language of our document retention policy. Now, companies have document retention policies, but the message wasn't that, oh, you should make sure your files are well organized so that the regulators can see exactly what you did with Enron. The message seemed to be shred everything in sight. By the time the SEC officially delivered a subpoena to Arthur Andersen, an awful lot had been shredded. The minute the subpoena showed up, they said, stop the shredding, stop. But by then it may have been too late, and so they were charged with obstruction of justice. Now, eventually, Arthur Andersen was convicted at a trial, and it was a fascinating trial because the corporation was on trial. And they hired a wonderful lawyer who kept saying, this is an innocent company. Why are you punishing the company for the actions of just a few employees? And, where's Waldo? Who's the criminal? Where's Waldo? There's this whole Where's Waldo theme throughout the trial. And so it was excellent lawyering. And you're impugning the name of this stellar Big Five accounting firm because of something a few people did. Now, ultimately, the jury convicts Arthur Andersen, and they pay a $500,000 fine. That wasn't a big deal. That did not put Arthur Andersen out of business. What put them out of business was that the SEC, the Securities and Exchange Commission, said, oh, well, now you're a felony convict, Arthur Andersen. You can't do business with public companies anymore. And if they can't do that, they can't do their business. And so
Andersen collapsed, in a very short period of time.
It collapsed. Actually, a lot of the highly paid partners were already leaving. They jumped ship. It was a lot of the low-level employees who really suffered the most, which is unfortunate. And so individuals didn't do time. Arthur Andersen bore the brunt of the punishment. And so in reaction to that case, people said this was an innocent company that was convicted and they were destroyed by these overzealous federal prosecutors. Something must be done. And so in 2003, the Department of Justice rewrote its memo providing informal guidance on how we charge corporations. This is how we charge a corporation. We have 9 factors which will guide our decision making. Now, the memo didn't say this, but this is what happened. What happened was basically, if it's a public company, if it's a really important company like Arthur Andersen, we will tend to give them out-of-court deals so that they don't get convicted like Arthur Andersen. And what they started to do was give companies what are called deferred prosecution agreements, or even non-prosecution agreements, which is just an agreement not to prosecute at all.
But let's talk for a second, though, about sort of the balancing act that was happening at that time, and also a little bit more of the context before that, because it is important to remember that in the years leading up to the prosecution of Arthur Andersen, there had been this series of gigantic accounting scandals. So many of the cases ended up pivoting around a defense like the one you just described, of essentially the company saying, or the CEO or CFO saying, I never told anybody to shred the documents, or I never told anybody to falsify those earnings. I did tell people over and over again, don't bring me bad results.
A lot of innocent people lost their jobs when Arthur Andersen collapsed. And the concern was we need to be more sensitive to the collateral consequences of the prosecution of a corporation. Since the corporation itself, if it's harmed, well, shareholders may be harmed. They didn't commit the crimes. Other employees may be harmed, and maybe not the ones who committed the crimes. Or consumers might be harmed, and it's not their fault, to be sure. Now, they also realized that it is complicated to prosecute corporations. And there's the question, can you just focus on the individuals who did it? If it's just a small group of individuals, if these were rogue employees, then don't bring in the corporation. Punish the people who did it. But if there was a culture in the company that was tolerating or encouraging the conduct, well, then it makes sense to fine the company too. And by the way, if they're victims, only the company may be able to make those victims whole. The individual executives may be highly paid, but they're not going to be able to pay hundreds of millions of dollars to make the victims whole. And so there are all these considerations about, how do we fix the company so it doesn't do it again? How do we regulate them? Who can pay the fine? Who is really at fault here? And what makes these cases even more complicated is that unlike a street crime, where there may be witnesses, there may be forensics, there may be some evidence of what happened, well, here, the crime scene is within the company.
Well, it was also fascinating to me at the time, digging into some of these cases, that it often did seem to be the case that you would have a fairly low-level person who had gotten a message from their boss, who'd gotten a message from their boss, who'd gotten a message from the chief financial officer, that they were really unhappy about numbers coming in this month that showed particular earnings that were not as strong as they should be, or missing things that should have been stronger, or units that should have been doing better. And it was the case that sometimes somebody making $60,000 a year working as a bookkeeper in an accounting department would fabricate a document. Once they got in the habit of this, they started generating hundreds and hundreds and hundreds of bogus invoices for billings that were never going to occur, and then creating ledgers of this. And in the end, it was never possible to demonstrate that anyone had specifically told them to do that, but they believed they had to do it, or that they would lose their jobs, or that their whole unit would be shut down.
Yeah, and I call it the ostrich problem in the book. That you could have an executive whose head is in the sand. They're willfully blind. They know that the message has been sent real strong to violate the law, whether it's safety rules or environmental rules or fraud or financial reporting rules. They're sending the message, but I don't want to read that document, just tell me that it's good, kind of supervision of employees. We recently had this trial of Don Blankenship, the former CEO of Massey Coal, and the structure of that trial looked very much like the age-old situation, going back to Health South, going back to trials long before, where the CEO says, mine safety, I care about that deeply. I have no idea what these mine superintendents are saying about a culture of non-compliance with mine safety law. Keeping separate books to show the inspectors, I had no idea. And the Massey Coal explosion.
Which killed 29 men, I believe.
29 miners lost their lives. It was an incredibly lucrative, high-grade mine. And so it sounds like what the CEO says is, I just said, dig the coal, dig it faster. I wanted money out of that mine. Now the supervisors who are testifying at the trial are saying, well, look, the pressure was on us. If we brought up safety stuff, the message was, don't turn this mine into a construction site. Don't be doing a lot of extra stuff. The focus should be on pulling out the ore and not safety. Now what made the case complicated and interesting was that insurance lawyers, and you don't want to cross insurance lawyers, dug up stuff that the prosecutors presumably wouldn't have known about. Maybe they would have found it. Tapes, and sort of Nixon tapes in the CEO's office. But even still, the jury deliberated in that case for 8 days, and ultimately they convicted the CEO of a misdemeanor where you don't have to show that he knew it. It is a lesser mental state for misdemeanors. Now maybe in this country what we need is more misdemeanors, where if the executive has responsibility for the violation and the violation is committed under her watch, then you can have a responsible corporate officer held accountable for a misdemeanor where they're not going to go to jail for more than a year. They may just pay a fine, but it's the crime of being a terrible CEO when horrible crimes are committed. Now we have actually that doctrine in a couple of areas, but we haven't used it too much in this country. And that might be something. If executives know that they will be held accountable for serious crimes, maybe that would be a good thing.
But the company itself was not prosecuted. It entered into an agreement with the government, right?
So the company enters into a deferred prosecution agreement. So the company has no criminal record, despite the 29 deaths. And the company had been bought by a new company, which says, we're going to clean house. The old CEO is gone. We're different. We've changed. We should be able to start with a clean slate.
And what's the problem with that?
Well, because the company wasn't convicted, if the company doesn't fix up the safety issues that it says it would, then what are the consequences? It may be found in violation of this out-of-court deferred prosecution agreement, but would the prosecutors even know how much monitoring is there? There's no judge supervising the agreement, and so what we've seen in these cases is that even when prosecutors learn that a company hasn't complied with what it said it would do to fix the problem, often they just say, we'll give you a little bit more time on the deferred prosecution agreement. So it's accountability light, and it's an out-of-court deal. So if the company does do it again years later, it has no record. It can say, we're not a recidivist. We've never been convicted of a crime.
And that speaks to this frustration of so many people over the last few years of that after the economic collapse of 2008, we came to realize some of the behavior of so many of the big Wall Street banks and other financial institutions. These banks, even if they caused the crisis, They had to be saved because they were too big to fail. And that did seem to be a rather direct outgrowth of the kind of logic that came from these earlier prosecutions of, well, we can't go in there, and even though these banks have done these bad things, we can't go after them in a way that brings on something even worse than the Great Depression. So we actually have to prop up these bad guys.
Yes, and I think too big to jail is an even more troubling problem than too big to fail. We don't want the global economy to collapse. I think plenty of people think that even if it wasn't done right, it was important to try to prop up the banks in the immediate aftermath of the financial crisis. Now, many of us wanted better regulation too to make sure that those risks wouldn't remain with us. But to say, okay, you're important, we want to make sure you're regulated right, and we want to make sure that you don't tank the entire global economy is one thing. But to say that you won't be held accountable for crimes, that's a very troubling concept, and that's just one of the too big to jail problems that we have in this country today.
I'm interested in what would be the ideal approach to these kinds of formulas, and in particular, the one party in these equations that seems most difficult to sort out are shareholders. I think it's pretty clear to us that it feels unfair for the employees of a company who had nothing to do with bad acts to end up having a brutal outcome from the collapse of the company or something like that. What is the right formula given all these issues?
One of the things I wanted to do when I was researching these corporate convictions was to follow the money and figure out where the fines were coming from, what corporations have to pay what, and how are they paying it. Now, one thing the Department of Justice has said, and it's true, is that corporate fines have skyrocketed. And you can see some of the graphics in my book or the information on my resource websites. And the University of Virginia Library, by the way, has been incredible in helping me collect this data. We never saw billion-dollar fines before, ever in this country. In 2009, we saw the very first paid by Pfizer, or really a subsidiary of Pfizer. Now billion-dollar fines are routine. Fines have gone through the roof. They've exploded, even just in the last 5 years, where all of a sudden you start to see $5, $6, $7, $8 billion in corporate penalties every year. What's interesting, though, is that those penalties, though, are borne mostly by the shareholders of public companies. We are not seeing more companies being prosecuted. We are not seeing more prosecutions of the individuals who actually committed the crimes. And instead, what we're seeing is large dollar amounts which prosecutors can thump their chest about and say, look at the money we're bringing in. But we're not seeing the kind of accountability that I think the shareholders would most want.
And how, by the way, is it that shareholders pay those? Just explain to us how that works.
Well, the fine is normally paid by the company, and it may be paid in multiple ways. When it's paid as a criminal penalty, when the fine is paid as a criminal penalty, it's not tax deductible. In some of these cases, though, there have been complaints that, wait a minute, actually the taxpayer is kind of paying the fine in a way. If it's a civil penalty or if it's a forfeiture or money to victims, the company can deduct that from their operating expenses. And so actually some of the fine may not be paid at all. But if the company is paying a fine and it's not tax deductible, then it's a loss for the company that year. Now, you could say, but wait a minute, the shareholders may have benefited from earlier financial fraud. And often, actually, the shareholders sue when it's a public company and say, look, you harmed us because you did fraudulent things that made the stock price look great, but it wasn't. And so we are the shareholders who got harmed by this. We want the current shareholders to pay us. And actually, when those suits are successful, often the fines paid in that securities litigation dwarf whatever fine the company pays to the government in the criminal case. These criminal fines, these billion-dollar blockbuster fines, of which there are more and more every year, are often a drop in the bucket compared to the harm that the victim suffered and that the victims receive in other civil suits or regulatory suits. So if you think about the Gulf spill, biggest environmental disaster in recent memory, BP paid several $billion in the criminal case. It paid the biggest community service any company's ever paid, $2 billion to study the Gulf, money for scientific organizations, $2 billion in community service, another $2 billion in a penalty. That's nothing compared to the almost $20 billion it paid to the EPA as part of a civil lawsuit. And they agreed with the president that they should compensate victims right away, so they set up a $20 billion or so victim compensation fund, which they've since been litigating and had disputes over. But the handful of billions that they paid as part of the criminal case was nothing compared to the money that they paid out in general.
But then there also were, in that case, criminal prosecutions of some executives.
Yes, mostly low-level folks. And what's really interesting about the BP story, actually, is that it's a too-big-to-jail story. There have been prosecutions for years. BP is a recidivist. They settled 3 separate criminal prosecutions in 2007. And I tell a somewhat heroic story of the victims in a Texas City refinery explosion, where a number of refinery workers lost their lives. I tell the story of a foreman who was hundreds of feet from a huge refinery distillery, sort of high-octane distillery that exploded. And he knew his wife was in a meeting in a trailer right by where this unit exploded. And so he runs in there and actually personally commandeers bulldozers and things to get wreckage off of the trailer. And he saves his wife's life. He saves a number of people's lives. He discovers his father-in-law dead in the wreckage. And the victims, including him, try to intervene because the prosecutors were going to let the company plea and pay a minimal fine and get no probation, no supervision. And they went in front of the judge and said, we're the victims in this case. We don't know why we weren't told about this plea deal. You're supposed to notify the victims, actually, under federal law. Somehow we found out about it. You should have told us. We think this is an unfair deal. It's not about money. We already sued and finally got some settlements for the damages we suffered. We're not asking for money here. We want accountability. We think that there was a culture of neglecting safety at BP. We've been complaining about these issues. There have been issues. Why wasn't there a flare? Why weren't the reports of inspectors listened to for a decade or so? This is a culture of ignoring safety. We want this criminal agreement to make sure that the conditions at the refinery are fixed because we fear for our lives every day going back to the job. The judge said, yeah, you don't really have a role to play here. I'm not going to listen to you. The appellate court actually reversed and said, no, you have to listen. And then the judge heard them and said, well, I'm approving the agreement the way it was before. They said, this is not going to work. More people lost their lives in smaller incidents at that very refinery. Several years later, the refinery is held in violation of all the things that it said it would fix by the EPA. They enter another agreement where they pay more of a fine, and they say, oh, no, we'll fix it now. And the victims keep saying, we told you so, we told you so. This is not being fixed. This is a company that doesn't care about safety. Something terrible is going to happen. And then you have the Gulf disaster. Yeah. And the same foreman said, basically, I told you so. We all told you so. And the courts wouldn't listen to us.
There's some presidential candidates who have talked about, Hillary Clinton in particular, I think, about how to improve the enforcement of corporate violations. And there have been, and you do have in the Department of Justice now, and a recent announcement of stepped up enforcement of corporations, and also by the same person who we talked about earlier, Sally Yates, also involved in re-examination of these faulty forensics. And so there are some big things happening, but in terms of big leadership, either from national leaders or local leaders, what's the call? What's your message to the next president? Your message to somebody else? What should be happening next?
Well, I've been certainly trying to have that conversation. I have been impressed with the attention that the Clinton campaign has paid to the corporate crime issues, and actually also regular street crime. I think it takes a plan. And you can't just say we're going to go after more individuals in corporate cases. It's difficult to do it. And the only comprehensive plan that I've seen it came out of the Clinton campaign where they said, no, you need more resources for corporate investigations. We should not be doing these out-of-court deferred prosecution agreements except in some unusual, exceptional case. Companies should be convicted. They should have to plead guilty and have court-supervised compliance. The fines should be real fines. It shouldn't be all tax deductible. So they actually had very detailed proposals for how to ramp up enforcement and do things to make individual cases more practical, like extend statutes of limitations. So I thought all that was really, really impressive. At the federal level, I also think we need an Innocence Commission out of the Department of Justice. The Department of Justice should be a role model for the country. And they do have a commission on forensic science now, which is important. In the late 90s, they convened a task force to look at eyewitness identifications. But there should be a permanent institution at the federal level that shows that the federal government cares about wrongful convictions, that they're going to fund efforts to research how to prevent wrongful convictions, and a commission within the Department of Justice that can investigate potential wrongful convictions. More and more prosecutors are creating conviction integrity units. The Department of Justice should have such a conviction integrity unit.
As a society, we've lost a passion for justice. And I think we need to talk more about that. A personal, individual passion for justice. And you've written 2 books that give us the materials to have that passion. So thank you, and thank you for being here.
Well, thank you so much.
Brandon Garrett, the book is Too Big to Jail: How Prosecutors Compromise with Corporations. We hope you'll join the conversation with American Forum on the Miller Center Facebook page or by following us on Twitter at Douglas Blackman or at American Forum TV. To send us a comment about this program or download podcasts or transcripts, visit us at millercenter.org, American Forum. I'm Doug Blackman. See you next week.